Thank you very much for having me here today. A lot of work on the right to information, anti-corruption, and in the National Campaign for People's Right to Information also, we talk about the Tamil Nadu use of the RTI Act and how it is being used so effectively by people. So it's really a pleasure to be here, and thank you for coming together and for all of us to have this chance to discuss. Um, I thought what we could do is that I'll just briefly talk a little bit about what are the issues with the DPDP Act, the Data Protection Act, where we are seeing the Right to Information Act going. So, how many of you have used the Right to Information law? Okay. Okay, wonderful. So many people have used the law here. The right to information law basically has come from Article 19(1)(a) of the Constitution, which deals with free speech and expression. The Supreme Court since the 1970s has been giving many judgments where they have said that the right to information is a fundamental right, and without the right to information, we can't have free speech or expression, because if we don't have information, how do we express ourselves? How do we formulate our thoughts? How do we speak freely? How do we express ourselves freely? Also, the Supreme Court has linked the right to information with Article 21 of the Constitution, which is the right to life with dignity. That for us to be able to get our basic rights, to be able to live with dignity, we need information. And in a democracy, when we say that government is of the people, by the people, for the people, you cannot have a situation where the government then tries to hide things from people. Because essentially, all the information that the government holds, they are holding on our behalf. It is our information. They are only custodians of our information. So when we ask for our information in a democracy, governments can't say, sorry, you can't have it, it's a secret. Now, just let me know whenever you want. Now, the Constitution we gave to ourselves in 1950. So technically, we've had the right to information through 19(1)(a) and 21 from 1950. But in reality, we also had the Official Secrets Act of 1923, colonial times, which basically, because of the colonial masters at that time, they didn't want to share information with their subjects. So they had a law which said that you cannot access information, it's all a secret, it is our information, you have no business getting it. Since the Official Secrets Act of 1923 was not struck off the statutes, even after we got independence and we said we are a democracy, that law was used to deny information to anybody who asked for information. So many people, even before the RTI law came, when they went to ask for information, like many of us did, we were told, no, this is a secret. You are asking for information, that's very good, but the Official Secrets Act exists and we will get into trouble if we share information with you. These are secret, state secrets. So what was very quickly realized was that for us to be able to get and actually realize our right to information, we need a law. We need a framework which at least partly overrides the Official Secrets Act and gives us a proper procedural framework to ask for information. And therefore, there was a grassroots movement, a demand that a right to information law be brought into the country so that as citizens, we can realize our fundamental right to information. And that movement, that campaign did not have people only who were lawyers or academics, it had people from across socioeconomic categories. It had people who were working working professionals, it had people who were living as as working as daily wagers, living in slum settlements, living in villages in Rajasthan, in Delhi, in Tamil Nadu, everywhere across the country. People came together and said, we want a right to information law which is effective and which we can use to get information from the government. And in 2005, 20 years ago, we got the RTI Act, which is applicable across the country. So I'm so happy that we are meeting now, because 12th of October 2025 was when we celebrated 20 years of the implementation of the RTI Act. And this law came on the back of 9 state legislations. So before the RTI Act was passed in the year 2005, there were 9 states that passed RTI laws. They taught us a lot, because some of the laws were not so effective. Some of the state laws were, had provisions which were not very, very progressive. But all the laws were used by people, because people started understanding that this is a very, very powerful tool for us to hold governments accountable. So when in 2005 the law came, it was already something that people had started recognizing that we need. It will help us to hold the powerful people to account. When the law was being drafted, there was a lot of enthusiasm, because at that time there was a window of opportunity. The UPA 1 government came to power. They had promised that we will bring a strong RTI law, and civil society was involved and engaged in drafting the law as well. And I remember at that time, a group that used to work with HIV positive patients came and said that, look, in our enthusiasm to make sure that information is public, we must not forget the right to privacy. Because there are so many people who could be adversely affected, like HIV positive patients, and that needs to be brought in. So I remember that perhaps one of the clauses that had the maximum amount of debate and discussion in the law was Section 81J of the law, which deals with privacy, with personal information. What does the RTI law, the basic framework, say? You all know it. I'll just say it so that we can move into the data protection discussion. The RTI law basically says that all information that the government holds is our information. For accountability, to fight corruption and wrongdoing, citizens must have access to information. So we can access all information from the government. However, there is some information that we feel cannot be shared with citizens unless larger public interest provides. So there is a section, which is Section 8 of the RTI Act, which essentially lists out what are the exemptions. So we can have information, but what is the information that we cannot ask for? Section 8 has all of that listed. So Section 8(1)(a), for example, says that anything that will harm the integrity and security and sovereignty of India, that cannot be asked for. So one would imagine that this is a reasonable exemption. Supposing the army decides to have some hidden bunkers somewhere in warfare, we cannot ask for it under the RTI Act that give me the exact location. That could compromise security of the people of the army. Similarly, there are other exemptions also. Fiduciary capacity, where let's say a doctor is given some information by a patient. You can't go and say that, I have RTI, please give me whatever the prescription was or what their health issues were. 8(1)(j) of the RTI Act is a very, very nuanced provision that was brought in to protect privacy of individuals. What it basically said is that any information which has nothing to do with public activity or interest, or would cause an unwarranted invasion of the privacy of an individual, cannot be provided unless there is larger public interest. Now, this is extremely important to understand the three things which the provision asked, made a niche, it carved out a niche for. It has to have nothing to do with public activity or public interest. So if I ask for information which I cannot prove that has anything to do with public activity or interest, that could be something that could be denied to me. The other is which would cause unwarranted invasion of somebody's privacy. So it's not that any personal information is exempt, only something that would cause unwarranted invasion of the privacy. So let's say somebody's health records is something you cannot go and ask for. It would cause an unwarranted invasion of their privacy. However, there was an overriding clause within this clause which said unless larger public interest requires it. What does that mean? Supposing there is a bus which takes small children to school, and the bus driver has some health problem and has seizures or something like that is observed. In that case, as a citizen, as a concerned parent citizen, I will have to prove that there is larger public interest in my seeking that information, and only then the information will be provided to me. Now, this was a very, very well thought out, nuanced provision that the 2005 RTI Act had. And this provision was used very extensively by the government to deny information. So, Section 81J is, when we've done research, it's the most used section of the RTI law to deny information. Because if you go to the government, they have understood now how powerful the RTI law can be and how powerful the disclosures can be for people to hold governments accountable. So we are seeing that governments don't want to share information and they look for some excuse to not give information. And perhaps the most used excuse has been Section 81J. So, for example, people asked the Reserve Bank of India, RBI, that public sector banks who collect our money, we deposit our money in public sector banks, they are giving these large loans to big capitalists, industrialists. And when they give these loans to these capitalists say that we don't have the resources to give back the loans. And the banks have come up with this great terminology called writing off loans. So if I were to say today that they have let go of the loan, they will come after me. They will say, you are lying. We have only written off the loan. But effectively, it means the same thing. These are willful defaulters. These are not like our farmers who are taking 10,000 rupees as loan and are actually not able to pay. Most of these people are willful defaulters, loan defaulters. So people under the RTI Act have asked that give us the names of these willful defaulters of public sector bank loans. To that, the RBI said, sorry, we cannot give it to you. And one of the reasons cited was Section 81J. It will harm the privacy of those people. The matter went up to the Information Commission, the Central Information Commission, and the commission said, what rubbish? This is people's money. How can you say this personal information will not tell you who we gave your money to and they've run away with that money? So the commission said you have to give the information. 81J does not apply. There is larger public interest in giving the information. So the RBI ran to the High Court. They lost there also. Then the RBI went to the Supreme Court, and the Supreme Court said you have to give. Similarly, there are many other examples where 81J has been used. For example, our Prime Minister, Mr. Narendra Modi, in his affidavit, which he gave before elections, he declared that he had done his graduation from Delhi University in the year 1978. Now, unfortunately, a lot of people said that we have never heard that he's a graduate from Delhi University. There is no student who said they studied with him. There is no professor who's saying that they taught him. And we want to verify it. They asked for information from the Delhi University, very interesting. They did not ask for the degree of the Prime Minister. They said that in the year 1978, give us the list of everybody who graduated. Now, what is there to hide? Anybody in this room who has ever graduated, I can see some students, they will graduate. It is an open convocation. The ceremony in Delhi University is even today telecast on Doordarshan. It's a moment of pride that you know who graduated. But for the year 1978, the Delhi University said no. This will harm the privacy of people who graduated in 1978. We can't give it. The matter again went to the Information Commission at the center, and the commission again said this is ridiculous. How can you say that this is personal information and therefore exempt and you won't give it? And then the matter went to the High Court. So what we are seeing is that the government is in this mode where they are immediately coming in, and for any information they don't want to give, they are citing 81J, which is bad enough. But what we have seen now is that 81J, the scope of it has been totally increased under the Data Protection Act. The Supreme Court has also held that the right to privacy is a fundamental right. In the Puttasamy judgment, the Supreme Court said that the right to privacy is important, and none of us can disagree with that. We don't want a state where they will come and put cameras in our rooms, in spaces like this where we want to have conversations, where we engage. There is no place for the state, and people have a right to privacy. And that's something that the right to information law also recognizes through 81J. The government has now brought a data protection law, digital personal data protection law. The reason we all call it the data protection law and not digital personal data protection law is that most of what we all have today is digital. We all have phones, even the poorest people have some form of phone, family will have one or something. So most of the data today in government and even in our personal spaces is digital. So we are basically talking about Data Protection Act, which says that we will protect personal data which is digitally held. Okay, the government wants to bring a Data Protection Act. One can understand it. We all are victims of all these phone calls that come to us constantly spamming us. Where are those people getting our phone numbers from? Obviously, data is the new oil. So they are collecting our data, they are selling our data to these big companies, and these big companies are then profiling us. They are using our data indiscriminately. There is cyber fraud, there is financial fraud. Yes, we understand that there must be ways to protect data, personal data. Who has the maximum amount of personal data? The government. UIDAI is probably the single largest repository of our personal data. Aadhaar, we have all given our names, addresses, biometrics, iris scan, everything we've done. The government is holding that information. It's big companies like Jio, like Google that are holding our personal data in the largest quantity. What does this law do? This law basically, and before I go into the provisions, I really just want to place the law in its context. This law is basically to give control on our personal data to the central government. There is no other logical way of explaining. I'll go into the technical details, but the broad stroke is the government has brought the data protection law to fully control and centralize the control on our personal data. There are two broad provisions under this law. One is that Section 44(3) of the Data Protection Law amends the RTI Act. What it says is that Section 81J, we are deleting everything in that section. The nuanced section is being deleted. And all that we are going to say is that all personal information will be exempt. So nothing to nuance it, nothing to say unless it has nothing to do with public activity or interest or causes unwarranted invasion of the privacy of an individual. No. Everything deleted, no larger public interest, just says what is exempt. Section 81J, all personal information. Now, this is such a huge blow because if you look at it, in all our use of the RTI Act in the last 20 years, wherever we have used it to fight corruption, wherever we have used it to fight human rights violations, wherever we have used it to expose wrongdoing and ensure accountability, we have asked for personal granular information. How? It rains and there is a road which has been constructed for crores of rupees, and in the first rain, the road breaks. So, what will I ask for in the RTI? The first question I ask is give me the name of the contractor. I want a copy of the contract. I want to know the name of the contractor who did this work. Obviously, they have indulged in corruption. Now they will say the name of the contractor is personal information. We cannot give it to you. Similarly, I will always ask in my RTI request that give me the name of the government official who signed off on the contract. Give me the name of the government official who went for inspection after the work was done and then released the money. I will be told the name of the government official is personal information. Their personal information cannot be given to you. How do we fight corruption? How do we ensure accountability? Somebody whose ration card is not getting made, somebody whose driving license is not getting made, passport is not getting made, Jati Praman Patra, their caste certificate is not getting made, they are being asked for a bribe. They file an RTI request saying name of the official who was responsible for processing my application. That's how they will demand accountability. Now they'll be told, no, this is personal information. Now when I go and ask for the names of loan defaulters from public sector banks, I will be told, you will be harming their privacy. This is personal information. You cannot have it. So these people can run away with our money. We can't ask our own government for that information. We have seen how election fraud is being alleged in the country. How do we fight that electoral fraud? Not just in this country, across the world. This is a principle across the world. You put out information on who is a voter, which basically means the voter list in the public domain. And then when people look at that voter list, they can say that, no, this is not my neighbor. This is my neighborhood, but so-and-so doesn't live here. Or XYZ's name is not here because they belong to a minority community or whatever it might be. That's how you check voter fraud, electoral fraud. But the voter list has our name, it has our address, it has our photograph. Now, after this law comes into being, it is very possible that the election commissioner, the chief election commissioner, Mr. Gyanesh Kumar, might come in a press conference and say, I am simply complying with the law, I am removing the voter list from the public domain. It's possible, perfectly possible, the way this law is drafted. So the amendment that they have made to section 81J completely disempowers people who want to hold the government accountable. The other change, the amendment that has been brought to the RTI Act through the Data Protection Act, is that there was a provision in the exemption clause which said that any information that cannot be denied to the parliament or state legislature cannot be denied to a citizen. Now, this is very important because what the law was essentially saying is that people are sovereign in a democracy. If there is information that you cannot hide from the parliament or the state legislature, you cannot hide from citizens. That has also been deleted from the RTI Act now. So it really shows the mindset with which the government has brought in this particular law. Now, the other aspect, which is equally important, because if we think about it, how do we all get personal information? I understand that there are some journalists also in the room. But for all of us who work on the ground, who work at the grassroots, how else, apart from the RTI Act, do we get personal information of people? We go out, we do a survey. We go out, we do a fact finding. So, for example, there will be people who will come to Satark Nagrik Sangathan, the people, women living in the bastis, and they will say that I have not got my ration card, I have got left out of the food security net, I want to apply for it. And we will make a list of everybody in that settlement who hasn't got a ration card with their name, addresses, and we will say that as soon as we find out anything about new ration cards being made, we will let you know. If there is other scheme, we will let you know. So we are constantly making lists. We are constantly, as groups that are working on the ground, collecting personal data on a day-to-day basis to carry out our work. Journalists, supposing there is a violation of any law that is happening, there is corruption that's happening, they don't always file RTI requests. They go to the ground and they expose corruption, they find out, they talk to people, and then they figure out what was the name of the contractor, who was working here, who came on the work site, their names they will put down. In Bhopal, close to Bhopal, there were extrajudicial killings of 8 people. People filed RTI requests, but journalists went on the ground. They did a fact finding. They found out what was the names of the people who were killed. They found out the names of the people who were in charge of those, that prison from which they said they had escaped, etc. And all of that was published. The government has now brought the law in a manner that none of this will be possible. How? The data protection law now says that anyone who processes personal information will be a data fiduciary. So anybody, you, me, a journalist somewhere, will all be data fiduciaries if we process personal data. What is processing? Processing involves collecting, analyzing, and publishing. So collecting personal data makes me a data fiduciary. If there is data that the government or anybody has given on a website, I analyze that personal data. It makes me a data fiduciary. If I go and publish any personal data of anybody, it makes me a data fiduciary. And what happens to these data fiduciaries? The law says you cannot process any personal data without taking permission, consent from the person involved. So now imagine that I am working in a village, I am working in a slum somewhere, and I'm collecting some data of people. I will first have to get them to fill and sign a consent form. A lot of people don't even understand, they are not being able to read or write, which is why they are asking someone else for help. They will have to first fill up a consent form and sign it. If I do it without that, I could be in trouble. If I don't do it, a complaint can go against a data fiduciary to the Data Protection Board. Like the RTI Act has a information commission at the center and has information commissions at the state level, in the Data Protection Act, a Data Protection Board has been set up. So if anybody has a complaint, including the government, they can file the complaint with the Data Protection Board. And the Data Protection Board will be fully controlled by the central government. Who will become a Data Protection Board member or chairperson will be determined by the central government. How they will be removed, who will be removing them, it's the central government. Their salaries will be decided by the central government. This board will be fully in control of the central government, and this board has been given the power to impose penalties on any data fiduciary, and not small penalties. The penalties go up to 250 crores, which can be doubled to 500 crore rupees. So now imagine the scenario. A journalist goes to a place where some crime has happened or some corruption has happened and finds out in their fact finding who was responsible, who were the victims, finds out if there is corruption that's happening, who is responsible for the corruption, some mantri somewhere, some minister's son, somewhere, some contractor, big contractor, brigade or whatever, somewhere, and they publish it. There can be a complaint that can be filed against the journalist in the Data Protection Board, and the board can fine them up to 500 crore rupees. This is what this law is doing. This law is basically saying that don't dare to hold us accountable. This government is basically telling us, the central government, that we are going to determine what action happens if you dare to hold us accountable. And the worst part, and which really gives away the intention of the government, is that it says that the central government will decide who is covered under the data protection law and who is left out of the data protection law. So now you can imagine that an Arappor or a News Minute or a Federal or somebody, all these news agencies that are trying to do some good work, ask questions, will all be covered under the law. But a Republic TV, a Times Now, some other BJP supporting NGO will be left out. So they will be told, you do your work without any worries, we are not coming after you. It is these people that we want to silence. This is what the law is doing. This law is completely giving control to the central government on who can use personal data and who cannot. And this is weaponization of legislation in its most blatant form. We are seeing how this government is weaponizing institutions and laws. This is a law that has been brought to be wielded as a weapon against any NGO, any activist, any citizen who dares to hold the government accountable, and against any journalist who tries to show truth to power. So basically, why do we say that this is a weapon that the government has created? It's because this law is empowering the central government to say that anyone who dares to question them, whether it is the opposition, political opposition, or it is people, they can be gone after under this law. We are seeing how laws like UAPA, like defamation, like PMLA are already being used against those who dare to question the government at the center. What this will do is that it will not even require a criminal proceeding. At least we know that today they will have to file an FIR. They will then have to do some kind of invoking of charges or whatever. In this, it's simple complaint. Nothing. Anyone can go and complain. And look at what this will do to our electoral democracy. We all know that today elections cannot be fought unless political parties have all their social media cells. Social media cells keep sending us messages, phone calls. BJP has it, DMK has it, AIDMK has it, Congress has it. Everybody has a social media cell which basically has personal data of people. Now, what this law will help the central government do is that they can declare the BJP social media cell exempt, and everybody else comes under the data protection law. So, which means that for every case of violation of the law, they can say that a complaint came, give 500 crore rupees. Now, imagine that out of a long list that you have, 10 people are coerced to, or they are planted, and then they go and file a complaint. 5,000 crore rupees will be immediately the penalty that the political party has to pay. I'm simply trying to say that this is a way of crippling any opposition in the country. Political opposition or opposition from citizens. And therefore, it's a very, very dangerous law that the government is bringing in. Of course, the penalty might be 1 crore, 5 crore, 10 crore, up to 500 crore. But if on Arappor there is a penalty of 5 crores, where are they going to pay from? So this is basically a way by which they are shutting down any opposition. A journalist, where are they going to get those 5 crore rupees from? So this is like a sword that is now hanging on the heads of anyone who wants to try and question. And this is very, very dangerous in any democracy to have a law like this. I'll stop with one provision that is worth mentioning, which really exposes the intention of the law. Section 36 of the Data Protection Act says that the central government can ask for any information from a data fiduciary. If you are trying to protect people's personal data, how can you have a clause like that? We know that today everybody has phones, has laptops, has some information stored in some place in a digital format. The central government is saying under the law that we can ask any data fiduciary for any information that they might possess. So imagine you're a journalist, you have a list of sources, you have a list of people who might be your protected sources. They will just say that because you're a data fiduciary, you are asked to give us your phone. Today, even when we are called to the CBI or to the ED and they try to ask for our phones or laptops, we always say, no, under what provision are you asking for this? We don't want to give you our gadgets. That's my invasion of my privacy. But now, under this law, it is a stated thing on statute that the central government can ask any data fiduciary to give them any information that they hold. There can't be anything that is more blatant, a violation of people's privacy and personal information. And this law is therefore has to be viewed as a weapon that the government has got to try and silence dissent and opposition. The law has not been operationalized yet. It was brought in August 2023. There has been a lot of pushback. Civil society has been up in arms saying you can't bring this law. It's amending the RTI law. It's going to criminalize so many of us. The journalist bodies have woken up and they're like, this is absolutely unacceptable. This is murder of free press. You can't do this. You are basically telling us to do propaganda. Anything else will be covered under the DPDP Act and you'll go after us. So journalists have been against it. And of course, some people in the industry, many are very happy, but some in the industry are also opposing it. So the government has not brought rules for the DPDP Act so far. Once the rules come, this law will become operational. We are told that the rules will be brought within this year. They were supposed to be brought in the end of September. We are now told that they will be brought this year sometime. I think it's very important for all of us to understand the dangers of this law and speak out against it. And it's very important, therefore, that we have these meetings, we have them everywhere in the country to raise people's awareness. We were shocked when we went and talked to lawyers. They said, we have no idea what this law has. When we talked to journalists the first time, many of them said, we don't have the time to sit and read every law that has been passed. We have not looked at it. So there are so many people who are not aware of what the government has done through this legislation. And we really need to organize and we need to oppose the law. Unfortunately, what we have seen with this government at the center is that when they don't want to listen, they don't want to listen. But at least it's important that we put a big pushback. If that also doesn't happen, we will really be left with nothing by way of our democratic rights. There will be a challenge that I'm sure there will be many challenges that will go to the courts. But we are seeing how the courts are working. Look at the electoral bonds case. They gave a good judgment, took 7 years to give the judgment. The appointment to the election commissioners, the selection committee, that challenge is languishing in the Supreme Court. There are nothing moves quickly, especially when it's political in nature in the courts also. So we need to really come out and protest, organize and agitate.